you're tried and convicted for an offense. You're not tried and convicted because you're a despicable, horrible person. The fact that you did something may make you a despicable, horrible person, but just being a despicable, horrible person doesn't get you convicted of a crime. You have to actually commit the crime, be tried on the crime fairly, and then convicted. Hello, and welcome to the next episode of Beneath the Law. My name's Gavin Ty. I'm here with my good friend, partner, Stephen Teal. And Stephen, we are, sometimes we get to talk about some fun, kind of amusing events. This one is despicable in so many ways.
Really? You think so?
I just feel like the whole episode of this character, every time it's just so gross. And you think of a better word to describe it. And of course, look, I'm a father of two daughters, but I'm not a woman. I can't imagine how women feel about this. Is probably far more revolted than the grossness that I feel. But we're going to talking about, of course, the one and only, probably not the one and only, unfortunately, but probably the most well-known of the greasy, despicable, molesting rapists, the one and only Harvey Weinstein.
Well, we're
back
certainly
in the news again.
We're certainly talking about a very seedy industry and conduct taking place in that industry. Mr. Weinstein certainly convicted in the state of California, was convicted in the state of New York, but that conviction has now been overturned. So, interesting subject. Certainly touches, Gavin, on the hashtag #MeToo movement, sexual violence in the workplace, and overall sexual conduct, particularly by male perpetrators against women at work. And so the subject is quite sensitive, and I think you're right. I mean, it's, for us to speak about it as men, certainly may not be the best perspective, but this is our perspective nonetheless in terms of this, and not a great outcome necessarily for the rights of women.
Well, maybe yes, maybe no. I think, first of all, you're right. It may not be the best perspective, that's for sure, but it is a perspective, I suppose. And I think that, one of the things that comes to my mind is when I was in my introduction of the topic, it's just talking about how, repulsive this character is and how repugnant he is to most people. And I think that's really what we're getting at in terms of what the legal issue why was his trial conviction overturned in the state of New York? And I guess it comes back to the issue of, as a fundamental principle of criminal law, you're tried and convicted for an offense. You're not tried and convicted because you're a despicable, horrible person. The fact that you did something may make you a despicable, horrible person, but just being a despicable, horrible person doesn't get you convicted of a crime. You have to actually commit the crime, be tried on the crime fairly, and then convicted of that crime. So evidence that goes to the notion that, hey, so-and-so committed this crime, and oh, by the way, they're a really awful, horrible person, tortured puppy dogs and whatever, that is really prejudicial to a fair trial. And I think that's fundamentally what the New York Court of Appeal was getting at, in a very incendiary, obviously complicated, as the dissent opinions talked about, and nuanced area, particularly in the area of sexual assault, where you've got a huge issue where people don't want to come forward, which is, I think, what the whole hashtag #MeToo movement was primarily about, which was just the courage to come forward and complain in the first place. And in that context, does that change the notion that you can't lead evidence about horrific, how horrible this person is in doing other things to prove that they did the crimes they're accused of?
Correct. Now, just as one correction, or I'm basically pulling you down off the ceiling. There was no torturing of puppy dogs in terms of this case, but certainly there was other evidence of bad character that the prosecution put forward with respect to Harvey Weinstein's criminal charges. So let's back up for a second, I think, Gavin. Let's talk about what Harvey Weinstein was charged with in New York. So I guess beginning in 2017, there were allegations of sexual abuse involving Mr. Weinstein, and so he was ultimately charged with one count of first-degree criminal sexual act based on allegations of forcibly performing oral sex on one complainant, also a count of rape and third-degree rape on allegations that he engaged in forcible intercourse and oral sex with another complainant, and then 2 counts of predatory sexual assault based on allegations that he engaged in attacks against A and B after having raped a third complainant, and that was dated back to 1993, 1994. So over the course of a long period of time, Mr. Weinstein is alleged to have committed acts of rape, sexual misconduct, and abuse against a number of women. He went to trial, and he was convicted. And at that trial, the prosecution led evidence of other witnesses that had bad sexual encounters or encounters involving Mr. Weinstein, not necessarily similar to the encounters that he was charged with, because each of these women who were behind the charges actually had lengthy relationships with him, whereas the other non-complainants did not have lengthy relationships with him. But that evidence was led. The prosecution also got a pretrial order to lead evidence of other bad character and bad conduct, bullying employees, shouting at people at restaurants, throwing objects, that kind of thing, which was allowed pretrial, which essentially would have gone to Mr. Weinstein's propensity to commit the acts that he was charged for. He was convicted, and then the state court of New York appeals court overturned that conviction majority 4-3. So that was the background and the context to what he was charged with, and the evidence that was led by the prosecution against him. And essentially, Mr. Weinstein argued in front of the state appeals court that meant that he had an unfair trial, because he has the right under criminal law, as here in Canada as well. A person that's charged with an offense is presumed innocent until proven guilty, and that essentially this evidence affected or negatively impacted that presumption by showing his bad character, that he had a propensity to do bad acts, he must have committed these crimes, and therefore turned it, for the majority of the state court in overturning the conviction, into a presumption of guilt. And so that was not a fair trial for Mr. Weinstein.
Yeah, I mean, I think let's just be clear about that. I mean, the other witnesses that were brought forward for what was, well, if not similar fact, sort of similar fact, sort of the bad character evidence, he wasn't convicted on any of those allegations.
He wasn't even charged with
he was not. He was neither convicted nor charged. So
right.
So let's just put that in context. If we had a accused is accused, let's put it in a different context. Let's say that someone was accused of being the cause of a motor vehicle accident, and the allegation was, that you ran the stop sign, and you denied that you ran the stop sign, and then they trotted out 50 people who said, I saw so-and-so run a stop sign on this date, or I saw so-and-so run a stop sign on this date. You had never been charged with running any of these other stop signs. You had no real ability to contest those charges if you had been. So there was no conviction. There was no finding that you had run that. But what would the jury would be left with the impression that you were a habitual stop sign runner. But that doesn't mean necessarily, does it, that you ran the stop sign that caused the accident, even if all those other allegations were true, not to mention that you'd never been convicted of any of them. So you can start to sort of back it up and say, yeah, that's really not very fair. He just trot out a whole bunch of people who are going to say nasty things about you. You put it in the context of sexual assault, of course, it becomes supercharged and far more difficult to take it away from the sort of antiseptic allegation of running a stop sign. This is far, far more accurate and as I said, supercharged of a type of an allegation. But you can start to see why that would tend to poison, so to speak, the mind of a juror, in the sense that it would prejudice the accused in the eyes of that juror to think that, well, if they did it once and they did it twice, they probably did it this time.
Yeah, and just to fill in some gaps, the prosecution wanted to lead 100 witnesses.
They probably could have found 300.
Who knows how many are out there? It ended up getting whittled down to just 3 other, I guess we call them non-complainant witnesses, because there were no charges in relation to the crimes that they were speaking about. So yeah, for sure, that's exactly what that kind of evidence does. And they have specific rules, I guess, in New York under specific cases. So one is called the Molyneux rule, and the other is the Sandoval rule. But essentially, in the Canadian context, it's really all about similar fact evidence and what is relevant to a prosecution's case, and whether that probative value of the similar fact evidence outweighs the prejudicial impact. And in Mr. Weinstein's case, it's a similar kind of analysis in New York. The majority of the court found that the evidence was irrelevant, and that the prejudicial value outweighed the probative value in any event, because the evidence just went to the propensity to commit these alleged crimes that he's been charged with.
Well, let me just pause there parenthetically for a second, because one thing that's always troubled me about this particular case was that, as I said, there was no conviction on any of these allegations. These were merely, as you put it, non-complainants coming forward, after the fact, saying, "Me too. Here I am. This happened to me too." But in the context of sexual assault, as I understand it, and I don't know if this is the case in New York, but certainly would be here in Canada, there would be no statute of limitation to bring those charges forward. There would be no statute of limitation on a plaintiff to bring a civil action for sexual assault. Was there any consideration given to the fact that the Crown or the prosecution in the U.S. couldn't just sort of skate around the obligation to prosecute and or get a ruling? Because they could. There'd be no time limit on it.
Well, I don't know about that, Gavin. I'm not up on criminal law. We've spoken about this before, I think in the context of Donald Trump and the allegations that have been made against him in New York, that in the state of New York, there are limitation periods depending on the severity of the crime. And so potentially there were some limitation period issues with respect to the non-complainant charges. There was actually a limitation period issue brought forward with respect to one of the complaints and one of the charges against Mr. Weinstein, but that was overruled by the court, that the limitation period didn't apply there. So, different legal landscape in New York than in Canada. So that may have been a factor. I don't know.
All right. Well, it doesn't in Canada. Let's just talk about this in the Canadian context for a second, because the notion of similar fact evidence is one you see quite regularly. Certainly in the civil context, we see similar fact evidence brought forward regularly to prove, for example, a course of conduct, and that the particular allegation of negligence was typical for this particular defendant, that's not an uncommon basis. In the criminal law context, though, there has to be a far more stringent control on what you've referred to as the ultimate test, which is the probative value must outweigh the prejudicial effect. In other words, it must provide the court or the trier of fact or the jury with an ability to discern fact that is more than the poisoning of the mind, if you will, that the evidence will necessarily entail. And if the poisoning of the mind, the prejudicial effect outweighs the benefit, the actual factual analytical benefit of the evidence, it should be excluded. Is that a fair statement of the test?
Sure, that's the general principle, and that's the general principle under the New York law as well. And in New York, there were certain exceptions to that rule, just as there may be exceptions here in the Canadian context. But from a pure academic standpoint, what you have in the Canadian context is you have what is called moral prejudice to an accused, and then you have what's called reasoning prejudice to an accused. And so the moral prejudice is this evidence, this similar fact evidence, can have an impact on the trier of fact or the jury, that they'll overlook weaknesses in the actual criminal case that's being put forward, and therefore just convict on the past immoral conduct of the accused. And so in Mr. Weinstein's case, if you put that in the Canadian context, the evidence of his bad character, screaming at employees, throwing objects. I think there was an incident involving his brother as well that they were trying to put forward. What really does that? What do those incidents have to do with forcible confinement and having sexual relations on a non-consensual basis? All it does is it taints his character, makes him look, despicable. You can throw all kinds of adjectives there in terms of his bad conduct, and therefore he gets convicted based potentially on the evidence of bad character. And the reasoning prejudice, just quickly, really what it does is it makes the case so complex that it then increases the likelihood again of a conviction and a finding of guilt. So that's really, in a nutshell, from a similar fact evidence analysis in the Canadian context, what a court would have been looking at through a Canadian lens. So similar in terms of what I think the majority of the state appeals court was looking at. Now, in the context of being at more of a chance to convict him with this bad character evidence, one of the dissenting judges noted that he wasn't convicted on everything. So maybe that evidence really did not have the prejudicial effect that the majority of the New York State appellate court reasoned that it did.
Wow, that's a pretty difficult. I mean, isn't the test that this evidence went to sort of an overarching view of this individual's character, separate and apart, I expect, from the question whether or not he committed these particular criminal acts. And, it's pretty hard to divorce the evidence of character generally from the specifics of an individual criminal act. I think, isn't that the point? That once the well is poisoned, that you don't really get into which glass of water you drank. It doesn't really matter.
No, I think this is a very, very difficult case from a evidentiary standpoint, from the legal standpoint, and now you overlay what really is a public policy kind of framework behind this case, because it involves this entire hashtag #MeToo movement and convicting bad men for basically using their positions of power to get sexual favors from women who don't want to participate in that kind of activity. And look, it's a very interesting industry. Certainly, part of this was this whole, part of the, again, underlying framework of this is this notion in the entertainment industry that there's a quid pro quo trade essentially happening. You help my career, and I'll give you something else in return to help my career out. And I think for the minority of the court, because these relationships were longer lasting than just one encounter, certainly some of these relationships seem to have lasted for years, I guess, to say that, that it's now, in the words of one of the minority judges, that the majority has just turned his case into a he said, she said narrative. And we've seen that in the Canadian context as well with Mr. Ghomeshi.
Yes. Well, that's a very interesting point that you bring that one up. Of course, that as I understand the way the evidence came out in that trial was that, again, there was evidence that there was a relationship, consensual relationship, in fact, a relationship desired by the victim with Ghomeshi after the alleged incidences, which was used by the defense to say, well, look, I mean, you're hardly texting the rapist and asking them out on a date after it happened if you were, in fact, it wasn't a consensual act. And there's some, I guess from some perspective, there's something compelling about that, in the sense that kind of makes sense on a certain level. I think the dissenting judges in the appeal in this case were saying is that you can't really look at it in that normal context, and that you can't look at the relationship, which is one of power and subservience, or this power dynamic that occurs, and take that out of the equation, and understand that for the victim, there was everything would be lost if they didn't preserve what this individual, this Svengali-like power that this individual had over their career and sense of self, I suppose, in some senses.
Yeah, I look at Gavin. I think it's a very complex kind of analysis that one needs to do, and there's probably psychology. There was certainly expert testimony speaking to that very issue as well before the trial court, with respect to a woman who gets into this kind of power dynamic relationship, and then stays in that relationship when they really, I guess, don't want to be in that relationship, and that anything that takes place because of this a psychology analysis is non-consensual. And I'm not a psychology major in any shape or form. I can't really speak intelligently about that, but my understanding is that there's expert analysis and research that has taken place to basically show that these power relationships, whether in the entertainment industry or elsewhere, where you have powerful men in position who use that position of authority to enter into relationships with workers at a lower scale, that there may be a non-consensualness about that, just because of the power dynamics that are at play.
Yeah, I mean, but what the Court of Appeal said, I think, is an important statement in the criminal law context was, quote, the general rule is that when a person is put upon trial for one offense, they are to be convicted, if at all, by evidence which shows that they are guilty of that offense alone, and that, under ordinary circumstances, proof of their guilt of one or a score of other offenses in their lifetime is wholly excluded. And I think that's important, certainly in the criminal law context here. If an accused has a record, for example, unless the accused puts their character in issue, unless, for example, the accused testifies, you're generally speaking, that record of criminal conviction would not go to the jury unless it was probative of a specific issue in the case. So, for example, I'm thinking like, this is going to sound awful, like true crime, but if there was like the Zodiac killer, it was a sort of MO that went with murders, and I mean that the evidence that, oh, here you put a Zodiac sign beside the body, and there was a Zodiac sign found beside this body, and he'd been convicted of a series of those offenses. Then I suppose that there's an argument to say that the probative value of that evidence is more than its prejudicial impact. Although it's pretty hard to divorce the two.
Well, I don't disagree with that. Look, I mean, we can look at this specific case in terms of what the issues were that the similar fact, we call it similar fact evidence, went to. So, according to the prosecution, there were contested issues on lack of consent, one, and the second was forcible compulsion. And so that's what they wanted these non-complainant witnesses to give evidence to. And for the minority of the court, they basically made a finding that indeed that's exactly what the evidence went to, and that it should have been allowed in, and that the trial judge made no error. And so, you get tied up in terms of legal analysis and legal debates, as depending on, I guess, which viewpoint you may be taking, that indeed that evidence fell within the exception to the rule of the general rule that you just previously mentioned, that you're only supposed to be convicted with respect to the offenses that you're charged upon, not convicted because of 100 other acts that you may have done or did do.
I think it bears mentioning, and I don't know if this plays, it's always difficult to say if this plays in a court's mind or not, but I don't know that any of this, as much as this was a highly touted ruling that was seen to really set back the movement. I mean, the fact of the matter is that Mr. Weinstein is very much incarcerated. He is going to be.
Well, he's in custody.
Well, isn't he? He's in prison in California, isn't he?
No, he's in a hospital in New York.
Oh, he's in a hospital in New York. He's in a. I can only imagine what kind of a hospital it may be. But in any event, he's charged and convicted in California, anyways. His sentences will last longer than his natural life, one would assume. I don't know that Mr. Weinstein will ever see the light of day again.
Well, I don't know, Gavin. My understanding is that the California decisions might be under appeal as well. But look, I think when and perhaps this is the inappropriate attention that has been placed on this kind of a case, that it really does have to do with the entire #MeToo movement. And in a way, it's actually a criticism. My understanding of #MeToo is that sometimes it concentrates too much on these high-profile cases, and when the results go against women, that it impacts the movement. And certainly, when you look at the two minority judgments, they speak very specifically to that public policy perspective of how the majority's decisions, are based on outdated notions of sexual violence and a naive narrative. One of the minority judges basically says as follows, that the majority decision represents an unfortunate step backwards from recent advances. So, we unfortunately have this pervading stream of public policy that flowed into certainly the decision of the minority. They spoke openly about it, and therefore, when this decision came out, the question is, does it impact the #MeToo movement or not? Gets discussed in the media, and really, quite frankly, I think it shouldn't impact the #MeToo movement for two reasons. One, it was based on rules and well-established rules of similar fact evidence. But two, more importantly, in a society like ours, should there really be any kind of sexual violence in the workplace at all? Like, that's not tolerable.
Of course not. Well, it's true about every crime. Should there be any crime? Hopefully not, but there is.
But we don't tolerate all those crimes.
You can't
right?
tolerate it. And hopefully that's all what the criminal law is there to do, is to show society's intolerance. In any event, a very interesting case, and a reminder again that the rules of evidence are there for a reason, and if convictions are to be maintained, I don't know, for example, in this particular case, what puzzles me is I don't really know why the prosecution needed it. I mean, it would seem to me that sort of this it was more for the theatrics of it than the actual conviction on the crimes for which they were prosecuting. And that, did the prosecution go too far? I mean, the Court of Appeal said yes. And it raises the next issue is, well, the remedy is, of course, that they order a new trial. And is anybody really going to go through that again?
I would just like to say, Gavin, New York is a place for theatrics.
Seems to be. It's interesting to
inside and
it's
outside.
Hard to tell whether they're courtrooms or Broadway stages, but in any event, sometimes it's courtrooms and trials and prosecutions should be conducted for the purposes of the legal issues in play, not for the political or theatrical aspects of it. And sometimes I think that when you go too far, you lose what you came to get in the first place, which was the conviction. So, I don't know that there'll ever be another trial. It's shameful that they'd have to put these victims of this through this again. How many of them are going to be prepared to endure that process another time? It's probably terrible enough the first time. But again, a guy like Weinstein, who is, as I said, odious and despicable, what do they say? Bad facts make bad law. And here we have a guy who is just so awful. I guess they just couldn't resist the temptation to paint him for the monster that he has been certainly shown to be. Okay, so before we go, we've dug up our positive review. A big shout out, thank you to NEWL85 for the wonderful comment. Really appreciate it. Thank you so much. And always remember that if no one is above the law, including Greasy Harvey, then everyone is beneath it.